Hello, everyone. Welcome to today's training event. This free online webinar on the IP protection for European startups and SMEs doing business in China. My name is Emon Wang. I'm from the Techcode Accelerator. Thank you, everyone, again to joining today's event. Together with me today, we also have Alessandra from the China IP SME Helpdesk powered by the European Commission to join today's session. And Alessandra will also give us an overview on the services and the support that's supported by the EU to help SMEs to better enter the Chinese market. We are also very glad to have Mr. de Tullio from the de Tullio and Partners, who is an intellectual property expert from Italy, I think, and to share his knowledge and the tips to everyone, to the fellow entrepreneurs and the startups founders in today's session. We will be also having a interactive Q&A session after the training. So feel free to use this the chat or the Q&A function on the GoToWebinar. You can find it in the navigation tools, which is appearing on your screen. You can interact with the speakers and also leave your comments or your questions, and we will gather them at the very end of the event. So that's a very short opening mark. I see people are still logging in, so we target to start at 10 o'clock, but I think allow me to use this time to also give you a very short introduction on the latest ecosystem in China, in Beijing specifically, which is the startup hotspot. I'm sharing my screen. I hope you can see everything. So to those who has not been to China due to the past 2 years of the lockdown, COVID and everything. So this is maybe something interesting to you because you might know Beijing is China's capital. Yeah, it's China's cultural center, political center, education center. But you might not know it is also the innovation center of China. So here you find more than 20,000 technology startups and SMEs in this one city. And if we're talking about Beijing, then we must talk about the Z Park. So Z Park is the so-called Zhongguancun Science Park, as known as the Z Park in the short form. It is basically the Silicon Valley of China. So if you are a startup, you're looking forward to meeting with other fellow entrepreneurs, meeting with investors, Z Park is your destination. The history of Z Park is basically very long. So it started in 1988 as the first technology park of China's, the first and only one. Started as a big computer market, I think. It's a mega market for 3C products, computers, communications, consumer electronics, and has been growing to today as a technology hub as China's Silicon Valley. So why is the success of this whole place? So I think to those who has not been to China, not very familiar with China, there's basically the tier 1 universities in China basically includes 2 universities in Beijing, that is the Tsinghua University and the Peking University, these 2 universities. And you can imagine all the talent and the spin-offs coming from these 2 top universities. They are going to, a lot of them are going to the business world, starting up their own companies, bring their R&D results from university to the market. So in Zhongguancun Z Park, in this area, you have today more than 90 new technology startups spinning off, launching every day. So that's really crazy. And if you think 90 new companies a day, among those, I think many of the names you are familiar with, like SenseTime, MegaV, that's the AI startups, unicorns, also Horizon Robotics, Momenta in the autonomous driving. If you're into the cryptocurrency, you must know Bitmine, who is the biggest Bitcoin mining manufacturer. So all these companies, they are coming from Z Park, from this business park. And I think maybe 1 or 2% of them can scale up to a global dominating tech giant. So I think now you can recognize more names on the right side: Xiaomi, Lenovo, Baidu, Didi, or ByteDance, the mother company of TikTok. So all these companies are coming from Zhongguancun area and has gone through actually very hard work to reach where they are today. So taking JD.com as example, the founder of JD.com, I think he started with a 10 square meter booth in the park area. But now his company is now the, I think, #2 e-commerce platform in China, direct competitor to Alibaba. So yeah, as you can see on this slide, many of the technologies you are familiar we hear from the media, like facial recognition, AI, autonomous driving, delivery drones, not without controversies, but I think China is a very good experimental ground for technology progression these days. So speaking of the ecosystem, you will find vibrant startup community, incubators and accelerators like us. But more important is the investors in Beijing. In Zhongguancun in Beijing, you'll find basically all the big names in Chinese venture capital and angel investment seen in this one single location. So this is very important for the ecosystem, the abundance of venture capitals. And this is very unique power to boost the technology scene in China. So I think I will skip this map part because Beijing is a huge place already. We cannot cover in one session. And if you are a startup, Zhongguancun is located on the, as you can see on the left side of the map, on the western part of the city. And you'll find the Chaoyang district, the Wangjing Soho CBD area in the eastern part of the city. And if you want to go for manufacturing activities, you can go to the northern part. This is starting from last year, there's this so-called China-Germany Park just opened. I think, yeah, we have it here. So our name is China-Germany Park, but I think it is also open for European startups, European companies, and not only the big technology giants, big corporates, but also for hidden champions, SMEs. So I think this will be like a kind of a, how to say, cluster for European companies, and especially manufacturing companies concentrating in Beijing area. And the last but not least is connectivities. So this is a new airport in Beijing, the so-called Daxing International Airport. I think you might heard of it on the news. It is the biggest airport in the world. So next time you travel to Beijing, I think you will be landing in this airport. Very interestingly is few people know that many international companies are also benefiting from such project. For example, in this one, the whole IT system was provided by T-Systems from Germany. So it is very surprising to many. Also, we have a very huge railway station. I think this is a typical big infrastructure you can see in China, the largest railway station in Asia. This is Beijing Fengtai South Railway Station. And also the architecture company for this project is a European company, GMP. So as you can see, as a European company, you can benefit from the continued growth in China and also share a portion of the market, especially in this technology-related fields. So I think we have most of the participants now joining the webinar. I think we have more than 20 participants now. So I'm slowly handing over the stage to my colleagues. At the very last, I want to quickly cover what we are doing at the Techcode. So we are an accelerator. We organize pitch battles events, as you can see on the slides everywhere. And typically we work with our community partners. We also organize our own event. And what we do is we often sponsor a China deep dive trip to sponsor startups and SMEs to come to China to really experience this phenomenon, this whole country. This China deep dive, of course, we go to Beijing, we visit Zhongguancun, Z Park, but we also go to Nanjing, Shenzhen, Shanghai, as you can see, to the trade fairs everywhere, delegations, speaker conferences. This is a typical photo I think you'll make from China. It's a lot of people, the group picture. Unfortunately, we cannot do these things in the past 2 years due to COVID. So yeah, at this moment, our focus is on the online part. We have a online China tech news portal called China Technology News KR Europe, which is you can make a screenshot. You can visit this website if you want to know the latest trend happening in China in the tech and the venture investment spectrum there. And of course, we also organize online events, also including events like this one on different topics. You can find us on Meetup. We are the biggest China-related meetup group on meetup.com. And yeah, I think it is good for us to make a preparation before we physically travel to China again. So again, very glad to have our partners today for today's event. And yeah, I'm handing over the microphone and the stage to Alessandra to give you a introduction on the China IP SME Helpdesk powered by the European Union. So I'm stopping my screen sharing.
Yeah, thank you. Thank you very much, Emon, for your introduction. And thanks, of course, for organizing this training with us. Hello, everyone. I hope you can see my screen. Yes, okay, perfect. Yes, my name is Alessandra Capriglia. I am project manager of the China IP SME Helpdesk. I'm going to introduce to you very briefly this project, and I'm going to moderate also the Q&A session. Speaking of, please do not hesitate to write down your questions in the webinar interaction tool. You can see like a little box. Our IP expert Elio will be happy to respond to all your inquiries, and it's a great opportunity, you know, to have a recommendations from a lawyer. So the China IP SME Helpdesk in a nutshell is a EU-funded project. We provide free advisory services to European SMEs, not only from European Union, but also from neighboring countries within the COSME program, so Bosnia-Herzegovina, Montenegro, Albania, Macedonia, and so on. We cover not only mainland China, but also Hong Kong, Macau, and Taiwan, each of them having a specific legal framework regarding IP. And we have helped for the last 12 years over 100,000 SMEs. This phase, the current phase of the project is coming to an end soon, but we will keep supporting and answering your questions until December, and then starting from next year, there will be a new phase of the project. So please do not hesitate to contact us at any time. We'll keep existing for sure. So in concrete, what we offer, we have an inquiry helpline. It's an email address that I'm going to share with you shortly, through which you can submit any questions related to IP protection and enforcement when doing business in China. It doesn't matter if you are just considering China right now and you're developing now an IP strategy to China, or if you're already in China and you encounter any problem, or you just would like to have clarification about your IP strategy. As we have also a team in China, so we can also support you on the spot. We organize on-site and online trainings and workshops, also webinars like this one, together with our partners who are European business support organizations. I invite everyone to go to our website to access free of charge all our materials. We have IP guides focused on specific IP rights or focused on specific sectors. We have real case studies from which you can learn from other people's experience. We have very schematic fact sheets and also overviews of the IP system of each of the China's jurisdiction. Yeah, here an example of fact sheet of mainland China, but you can also find one about Taiwan, Hong Kong, and Macau. And here on the right side, you can see an example of an IP guide, in this case, tech transfer. The China IP SME Helpdesk is part of this big family of international IP SME Helpdesk under the European Commission umbrella. We all offer the same services, but of course we cover different regions around the world, namely Latin America, Africa, India, Southeast Asia, China, and the European region as well. Note the website and go visit the website and to get all the contact details. And again, all the services are free of charge for all European SMEs. Stay connected. Feel free to follow us on social media, where we promote our upcoming activities, where we promote our latest materials, and on YouTube we upload, you can find all the past webinars and some informative short videos. Here is the helpline address. Feel free to contact us with any question, and we respond within 3 working days. Of course, it's confidential. So we're here to help you. We exist to support your internationalization to China, as IP is an extremely important asset, but Elio will tell you more about that. So I hope you will enjoy the training. Thanks a lot again to Emon and to Elio de Tullio for organizing this event with me. And I will give the floor to Elio, and I'm going to allow you, Elio, to present. Thank you very much, everyone. And again, feel free to ask any questions in the Q&A box. Elio, the floor is yours.
Thank you very much, Alessandra. Thank you very much. I'm just fixing the screen. Okay. Okay, can you see the screen?
Yes, we can see it.
Okay, perfect. So today we will, I will put my presentation in full screen mode.
Perfect.
Okay. So today we will present the main hints and tips to partnering for success in China. My name is Elio de Tullio. As you can see from the from this slide, it's still trying to. Sorry. So my name is Elio de Tullio. I'm the founder and managing partner of the Tullio Partners. We deal with intellectual property at international level, but our main goal is to assist SMEs and EU companies to protect and enforce IP rights in China and in mainland China territories. Today we will first speak about the protection of intellectual property rights in China, but we will also present some tips in order to select the right business partners in China and to secure your business when you start partnering in China. First of all, bear in mind that the only registered IP rights are protected in China, since let's say used IP rights have a limited protection in China, even if there was a reform in 2014 allowing unregistered trademarks to be protected for some reasons and according to some rules in China. China adopts a first-to-file system for IPRs, so you are really kindly suggested to file and register your IP rights in China, because the registration procedure takes some time, either for patents but also for trademarks and designs. So the best solution is always to have in your hands a registered intellectual property right. Another best practice is to have 2 experts supporting you if you are a European company regarding all activities to be done in China, a local agent and a EU agent. So the EU agent for EU companies should help companies to design the right strategy to protect intellectual property rights in China and to give direction. Then, of course, he or she will liaise with a local partner, local agent in China for all operative representations, for instance, before the CNIPA, before the China National Intellectual Property Administration, or before national courts. In terms of trademarks, it is not expressly required by Chinese law to provide the office with the Chinese transliteration of the mark, but it is highly recommended to protect the transliteration of your trademark in China, as we will see afterwards. The trademark protection lasts 10 years from the grant and can be renewed indefinitely for periods of 10 years, while the patent protection lasts 20 years as in the rest of the world, and design and utility model protection lasts for 10 years. But pay attention that there was a reform in 2021, so for those designs filed after the 1st June 2021, the duration of design is 15 years from the filing date and not 10 years that remains for the previous filed design application. So these rules are not enforced, as Alessandra mentioned, in Hong Kong, Macau, and Taiwan, that have different, let's say, legal system. But of course, you can find all this information regarding Hong Kong, Macau, and Taiwan in the material and fact sheets of the China IP SME Helpdesk. As to registration authorities, there was a change in 2018 regarding the management of IP rights in terms of registration authorities. Now, let's say, the sole authority for industrial property rights is the China National Intellectual Property Administration, that has competence for patents, utility models, designs, but also trademarks and geographical indication. The copyright is still under the authority of the Copyright Protection Center of China, authorized by the National Copyright Administration of China. China is member of the Madrid system managed by WIPO for trademarks, but also member of Patent Cooperation Treaty regarding patents, signatory of the Paris Convention that provides the priority rights. So the owner of an application for registration of an IP right filing one of the member states of the Paris Convention may use a priority period of 6 months for design and trademarks or 1 year for patents and utility models from the filing of the application in country of origin to extend the protection of the first filing in China through a national filing in that country. So in this case, the starting date of the protection will be the date of the filing in the country of origin. So as you can see from this slide, China is very active at international level, and is the object of protection is in line with international standards. So let's say that is a member of all international convention of intellectual property rights. Some consideration before engaging with business partners in China. So first of all, you need to check import-export catalogs, in particular if you are dealing with technology transfer matters, or let's say high technological products or services, because some activities are not allowed, even if you know the list of these the list of activities allowed for foreign companies has been extended lately. Keep information confidential. This is let's say the mantra of your liaison with the Chinese partner, because let's say confidential information has a limited protection in China, and only if they are qualified as trade secrets that can obtain protection before Chinese court. So we will see some additional details on this afterwards. Start protection in the country of origin. So you need to start in Europe, even if you are foreseeing to extend your business in China in 1-2 years. You need to start now, because you need to carry out preliminary searches for trademarks, design, patents. You need to see if the legal requirements are matched for the Chinese protection. So at the end of the day, the only way you have in order to assess the protectability of your rights in China is to carry out searches to see if your trademark has distinctive capacity, is new, or your patent has inventive step and is new, and your design has individual character and is also new. Use priority rights, so you can postpone some costs to subsequent years. So you can start the protection now. You just can file a protection in your country of origin, file your application in the country of origin, and then extend the protection in 6 months or 12 months according to the opportunities given by the Paris Convention, as mentioned before. Analyze carefully the regional challenges. I already mentioned the different jurisdictions of Macau, Taiwan, and Hong Kong. Of course, select what IP register, because a product can be protected through different intellectual property rights, and sometimes the interdependence of these rights is an tool that you can use for enforcement matters in order to better protect your products against counterfeiters or people who like to copy them. Assess the legal, tax, and regulatory landscape in each country and secure trade secrets, but we will go through this afterwards. Some changes to the regulation of the administration of the import and export of technologies and adoption of the new foreign investment law have removed, as mentioned before, many restrictions on foreign investment to offer foreign companies national treatment in most sectors. So the same treatment as applied to domestic Chinese companies is applied to foreign companies as required by TRIPS. National treatment means that foreign investors will be treated no less favorably than Chinese investors at the entrance stage, so long as the invested industry is not on the negative list of this import-export catalogs. So the protection during the entrance stage guarantees to foreign companies that they will be treated equally with Chinese companies when applying for business license or any permission needed to operate in China. So once again, check this negative list for foreign investments. This list is periodically updated, and the analysis of the negative list for foreign investment should be done in the early stage of your business internationalization plan, because of course from this can depend the level of interaction with your Chinese partner, and also the legal instruments to be used in order to implement this relationship. The due diligence that you should carry out before entering into an agreement with your Chinese business partner is a key issue in China. You have to choose your local partner carefully. You have to carry out accurate investigations, and of course the disclosure of information at the very beginning should be planned in a very careful way. The negotiation, it is advisable to start and prosecute a negotiation step by step. So for instance, first of all, signing an NDA or an NNN, as we will see afterwards, then a letter of intent of an MOU, memorandum of understanding, and then all negotiations and change of information should be done in written, so no, let's say, communication, oral communication. The structured models can be a joint venture or a wholly foreign-owned enterprise, or a license that is very common, but is the one with the, let's say, the less control on intellectual property right. Of course, before entering into agreements with Chinese partners, you also have to analyze your strengths, and you have to analyze your competitors and the Chinese market in which you wish to operate. For instance, to have a clear idea about the IP landscape, but also the commercial landscape, of course, investigate about your Chinese partner's specific objectives, or try to understand some key situation that can influence your cooperation. And then you can design your own procedures when dealing with China. And the NNN, so the non-disclosure, non-use, non-circumvention agreement, is a way to secure your business. We will we elaborate more about this afterwards. One way to get information about your Chinese company, your Chinese partner, is to have access to the National Enterprise Credit Information Publicity System that provides public access to official registration data for all legal entities in China. And the registration data also contains names of key individuals of the companies. So let's say that this website of the National Enterprise Credit Information Publicity System is in Chinese, but you of course can use also Google Translate to have an interface in English. My suggestion is always to liaise with your EU IP attorney and your local Chinese IP attorney in order to get this information, because the important is not the collection of data, but the interpretation of data. So those suggestions that these data can give you in order to understand better who is your Chinese partner. So this information can give you some green light or red flags regarding if the company is an officially registered company in China, who can legally represent the company and sign contracts on behalf of the company, what the business scope of the company is, where the company is located. And so this is a way you can get information on your own or through your IP attorneys. The information from this online search does not give you a comprehensive information. So this information should be, let's say, cross-checked with the information you can get from your Chinese partner. So then you need to put all the piece of the puzzle together and try to compose the drawing. Bear in mind that since China is a very far country, also in terms of legal system, I would say that it is better to reduce risks of any kind of issue in this country. Of course, the importance of contracts is crucial. Contracts involving the protection of IP can be divided into 4 main categories: technology development, transfer, consultancy, and service contracts, trademark and copyright license contracts, but also patent license contracts, manufacturing, distribution, and sales contracts, employment contracts. And one of the key point is, as mentioned before, the protection of confidential information. Not all confidential information can be protected in China, and but also, let's say, trade secrets. So define it as any non-public technical or business information with commercial value that is guarded by confidentiality measures. You need also to show that these information are not publicly available, that have an economic value, and your company has implemented technical, legal, and physical measures in order to keep them secret before sharing them with your Chinese partner. One way is, of course, the NNN. The content and focus in each type of contract can vary according to the specific IPR to be protected. So key provisions are the definition of license of rights, the monitoring of licensees' activities in order to prevent unauthorized use of the license of rights, challenges of validity in order to ensure the validity of your agreement, of course, the ownership issues, if any, because if there are some, for instance, new technology coming from research and development activities, it should be clear who owns the ownership. Then what happens for IPRs produced by employees in order to avoid future disputes, and provide, let's say, good system of dispute resolution, even with the election of the right competent court, and of course the courts of the first line, let's say the Taiwan cities are better than other courts for judging IPR proceedings. I'm meaning Beijing, Shanghai, Guangzhou, Haikou, but of course there are also other, let's say, good courts in other cities of China. And specify what happens when the agreement terminates. For instance, one important clause in IP contracts is declaration of warranties. So what you declare about your IP right, and of course, if you have a registered IP right, is better than it is still an application, so you are not sure about the granting. Localization, so complies with the laws of the country in which you are operating. Sometimes the election, the designation of the Chinese court and the as competent court and the Chinese law as applicable law is better, because then you can enforce your rights in China directly. And other clauses can be the terms to ensure proper use of IP, the terms to ensure IP is registered and owned by rights holder, terms to get out safely and ensure that your IP is not used beyond the contract term, and terms to ensure continuation of the business after the ending of the agreement. Then, of course, there are other specific clauses, clauses about the audit, so the possibility to go and see if your licensee or your business partner is using the IP rights beyond the scope of the contract. What about the recordal of license agreements? Let's say, giving your business partner, your Chinese partner, the responsibility to watch for infringements of third parties and ensure that the contract allows for local enforcement. Sometimes if you have to enforce your rights during a trade fair, for instance, this should be done in few days, and your local partner should be trusted and should be also entrusted to act on your behalf in order to secure a prompt action in case of violation. I will leave this other examples of IP provision in my slides, because you can probably I can focus a little bit more about the provision to avoid. So what are the provisions that can be objected in China? Let's say provisions to avoid probably is misleading, because of course you can try to put these provisions in your contracts, but then you can have problems to enforce the contracts before the court. So provision to avoid in technology contracts can include those that prohibit the licensee from making improvements to the licensed technology and using the improvements, restrain the licensee from obtaining from other parties technology similar to or competing with the licensed technology. A licensor cannot make any unreasonable restraints on licensees' procurement channels, prevent a licensee from making full use of the licensed technology in a reasonable manner, or require a licensee to accept additional conditions that are unnecessary for the use or working of the technology, or prohibit a licensee from challenging the validity of the IPR of the licensed technology, or from attaching additional conditions to such a challenge. And there are also provisions to avoid in employment contracts. For instance, they include those that state that the employer owns the patent rights and or copyright of any non-employment related work or creation, exclude any remuneration to an employee for his or her patented creation, or impose unreasonable non-compete or non-solicitation obligation upon employees. For example, making non-compete obligation last for more than 2 years or not remunerated, and waive monthly compensation to employees for fulfilling their non-compete obligation. Other provisions that can be avoided are those that exempt the party from liability for causing the other party bodily harm or property losses and require Chinese IPR to be governed or protected by law of other jurisdictions. Once again, it's better to use the Chinese jurisdiction and the Chinese law for any enforcement in China. This is a slide about non-disclosure agreement and NNN. As mentioned before, NNN are, let's say, an upgraded version of NDAs. Usual normal NDAs, standard NDAs cannot work in China. So you can use this NNN. The non-disclosure provision will cover the unauthorized disclosure of confidential information, but then there will be a non-use provision that will state that the Chinese manufacturer cannot produce your product or any similar products for anyone other than you. And the non-circumvention provision will prevent the Chinese manufacturer from bypassing the protection or circumvention means of technologies of the product. Another important part is related to IP protection enforcement during trade fairs. You can enforce your rights during trade fairs in China. Sometimes for trade fairs that last more than 2 days, it is established an IPR bureau that can be entitled to implement any enforcement action that right holders can start during the trade fair. So if you see any violation, any infringement during the trade fair, no panic. You need to collect evidences because the burden of proof is on plaintiff usually in China. So you need to make photos. Sometimes you can also be assisted by a public notary in order to collect these evidences, and then you can go to the public authorities dealing with IPR protection in China in order to start, let's say, a preliminary measure proceeding, and so try to seize the product that counterfeit your rights. So the main suggestion is to be ready to react, because then if everything has been done correctly, you will receive a prompt protection in China. Sometimes it's better to go to a court in this first tier cities, those mentioned before, because there you have specialized IP courts. In China, there are 4 specialized IP courts, so Beijing, Shanghai, Wenzhou, and Haikou. And in these courts, you can find good satisfaction for your rights. Some additional hints about trademarks. All non-conventional trademarks are allowed in China. You can also have the possibility to protect your trademark in different classes with one application. So multi-class application is available, but pay attention to sub-classification adopted by CNIPA, because sub-classification is quite tricky in China. Trademark application can be filed electronically, and so in any case, for all these classification and filing issues, please liaise with your IP attorney. Regarding patents, China is part of the Patent Cooperation Treaty, so the patent can be extended internationally in 155 countries, but of course you can also choose the national path to protect your invention in China. The authority, once again, dealing with the patents, utility model, and design is CNIPA, and the difference between patents and utility models is that utility models are small patents. Here you can see the classification of patents in China. So you have invention patents, so a new technical solution that have novelty in high level of inventive step. So an expert of the field should be able to consider the invention, the solution, not obvious, not easy, accessible. Then you have utility model patents, so small inventions that can last 10 years rather than 20 years and are more easily to obtain because there is no substantial examination from CNIPA in order to assess the inventive step and the novelty. And then there are design patents that protect the aesthetical part of the feature of the product, and so they are fit for the let's say for protecting ornaments or all the decoration of your products. For instance, design patents can protect the shape, the pattern, the shape of the pattern, the shape and color, but also the material and all the combination of these elements together. Finally, copyright usually is used as backup rights, is the protection of any artistic work, but sometimes can also protect the collection of data like database, but also images, videos, and any kind of creative, literary and artistic work. I will leave this slide for any issue regarding the procedure for protecting copyright in China. The only two points are, first of all, that the protection starts without any formal filing, but the formal filing is very useful in order to reverse the burden of proof. So you can then have less problem to enforce your rights before a court. And the second one is that you have a distinction between moral rights and economic rights in copyrights, and so your moral rights cannot be, let's say, in any case transferred. And the duration of protection is equal to the author's life plus 50 years after his death. So here you have also some additional information regarding the registration procedure of copyrights. I will skip the case studies and go straight to the conclusions. The key recommendations are, first of all, selecting your strategy according to a preliminary assessment based on investigation and searches. When I speak about searches, I speak about trademark, patent, and design searches in order to assess the patentability, the protectability of your rights. Start protecting your IPR in Europe before entering the market. You have the priority rights, so you can start any activity having 6 months or 1 year to implement them at Chinese level. Prepare a plan to develop your IPR protection in medium long term. You can also assess costs during the first year in order to be lighter in terms of budget. Carry out your preliminary searches. Take care of your first filings. Your first filing, for instance, in Germany or in Italy or in European Union or a TPO, the European Patent Office, can be the pillar of the international protection of your IP rights. So should be solid and should be well made. And then you can think about China. Collect all the documents related to your IPR to create a database with all relevant materials if you have an infringement to afford. So you should be ready with all your repository. Monitor markets and competitors' behavior. So once you start your business in China, this is not the end, but the beginning of your path, because you need to be careful about what happened there, even with the help of your Chinese partner. Activate a worldwide surveillance system. You have a systems and database that can inform you about any infringement in real time, so you can react accordingly. Monitor IP gazettes and legal actions, and finally verify the compliance of contracts providing local law as applicable law, because you need to be ready and aware about all consequences from the very beginning, because once the infringement is there, you should be able to react accordingly. So thank you very much. For any question, you can go to the China IP SME Helpdesk website, as Alessandra said, or you can write me an email. Thank you.
Thank you very much, Elio, for this presentation. I'm sure it's been useful for a lot of people. Yeah, I don't see any questions right now still on the chat box. I will give a few minutes to the audience. But yeah, I feel like for startups interested in China, there are like so many, well, pre-COVID at least, there were so many events, like competitions, and there is a huge interest from Chinese incubators, accelerators, science parks, and so on to attract European companies. And very often, probably European entrepreneurs sort of expose their product a bit too early without having done their homework regarding IP. So what I would like to say is that before you talk with somebody, or if you have any doubt, do feel free to reach out to us to you know, sort of understand how best communicate with potential partners. This doesn't mean that you should not do business in China. Of course, it's a great market, but it's good to protect your assets. Emon, do you have maybe any questions that, I don't know, companies ask you very often in relation to IP, or it could be also like all those very I don't know, common irrational questions like, oh, Chinese will steal my IP, so I'm not gonna go there. Like how is the how's the yeah, how are European companies when it comes to IP? Like do they comment on this when you talk to them?
Yes, I think you mentioned very actually also one of my questions on my list is because we work with a lot of startups, and as you know, startups tend not to have all the IP protection patents registered upfront, you know, and especially during the COVID, we do a lot of like this kind of online matchmaking, online presentation, road shows, pitching events, and there's this like a pitch deck, you know, it's like circulating everywhere, and especially we also get these questions, you know, from Chinese, from European startups. You know, if we do this kind of a remote pitching event with Chinese investors, audience, we must show them something, because on the pitch deck you show your product, your innovation, but is it actually anything we can do to somehow to add a layer of protection onto that? Because on one side we want to show off, you know, what we are doing, our innovative products, how it looks like and everything. But on the other side, for startups, many does not have these resources, you know, to put a heavy toolbox, you know, to protect their IPs. So I don't know if you guys have any recommendations, especially for small companies, you know, startup companies, to somehow protect themselves.
Well, Alessandra, can I jump in?
Yeah, of course.
Okay, so let's say that if you are a startupper, or you are a small company, and you start getting in touch with, for instance, the China IP SME Helpdesk, or the EU initiative for SMEs, you will get a lot of information about even financial support to IP protection. For instance, EUIPO, the EU Intellectual Property Office, has launched this SME fund that refund all of, let's say, 75% of official fees related to trademarks, patents, and design application for starting your protection in European Union. And the project will also aim at extending this reimbursement for international protection in foreign countries. So let's say the starting point is always the protection in the country of origin, so let's say in Europe, and then you can use international convention to extend the protection in China. So for this first protection in Europe, you can use this SME fund. But there are also other initiatives at European Commission level. There is the IP Scan initiative offering SMEs due diligence regarding your IP rights, if you are, of course, an SME. There are other initiatives at national level. For instance, there was a huge project called IP Booster, supporting with services up to 25,000 euros amount, public research centers and spin-offs. So there are a lot of initiatives. If you get into this world, that is the IP world, you, first of all, you will receive a lot of useful information that you can use before starting any disclosure of information with Chinese partner. And then, of course, you can receive free services. You can receive also assistance, and sometimes you can receive also reimbursement of some costs. So I would say that the suggestion is to stay tuned and contact the China IP SME Helpdesk, and you will get ready to go to China.
Thanks a lot. Actually, we do have some questions. Let's see. Okay, oh, 1 second. God. Should we set on contract local enforcement location in Hong Kong or rather mainland China? I'm not sure what this question mean exactly.
Well, let's say that Hong Kong has its own, let's say, competent authorities in terms of IP. For instance, if you like to protect your IP rights in Hong Kong, you have to file an application using an IP attorney in Hong Kong, and that will liaise with the Hong Kong IP office. So let's say, once again, you need to consider these as different jurisdictions in terms of IP world, even if they are part of the mainland China.
Yeah, I think it's because like a lot of companies start off in Hong Kong as it is traditionally an easier market, and then they wonder if, you know, they should or should not register their IP also in China. But yeah, as you said, Elio, it's they should consider these two jurisdictions as different markets. So it's good to actually register in both.
Yeah, the protection in Hong Kong is usually quite expensive compared to the protection of China in China, because of course there is a high number of companies that would like to start, you know, the interaction with these Asian countries in Hong Kong that is, let's say, easy to afford.
Mm-hmm. Yeah. Now, another question. Since it's not allowed to set forth a prohibition to challenge the IP, is it possible to add a clause of termination in case the licensee challenge the licensed IP right?
You always have the, of course, if you are a licensor and you have your licensee in China, it's always to include. It's always advisable to include in the contract reasonable clauses, and so to make the collaboration closer and not farther. So I would say that I would avoid any clause that could generate a lack of confidence. You will always have the possibility to challenge an IP right, even if you don't have a specific clause in the contract, while to include a clause in which you, let's say, prohibit the licensee to challenge the validity of an IP right could be quite not easy to be accepted as a valid clause.
Okay. We have one last question. Should an NDA also be governed by Chinese law?
Yes, of course. As I suggested before, it's better that the NDA. I would say that the NDA doesn't really work as it is considered in Europe. Cannot work in China and cannot be, let's say, enough to protect your IP rights in China. So let's say everything, of course, should be checked regarding different factors. For instance, what is the court involved in the judgment, how the NDA is written, what are the main clauses, what are the consequences, etc. And also the ability of your lawyers to enforce your NDA in China. But as a general suggestion, the standard NDA doesn't work in China. I would add that the standard NDA doesn't work even in Europe. So an NDA should be tailor-made. So it should be, let's say, drafted according to your needs and to your goals. Otherwise, a general NDA is not a good way to start. So first of all, bear in mind that at worldwide level, NDA should be tailor-made. Then, secondly, in China, the validity of this NNN has been, let's say, ascertained by courts. So when you oblige your counterparty to sign an NNN, so non-disclosure, non-use of circumvention, then your protection is stronger. That is why we said that a standard NNN should have some problems to be enforced, while a stronger standard NDA should have problems to be enforced, while a tailor-made NNN can help you better to protect your position in China.
Yeah, so it's worth spending some time and energy to do those contracts properly instead of rushing up and avoid then any conflict.
Yeah, and then sorry if I interrupt you. And then usually we are not meaning of you know, these kind of contracts can be obtained with the limited budgets. So I would say that there are a different way to start your business with Chinese partners. Probably the best money to spend are those in NDA, NNN, and this kind of preliminary agreements.
Yeah.
Can I add one question as addition to the contract jurisdiction location topics? because often we see the situation that we have one like a Chinese partner who's like insisting on putting the jurisdictions in China. This is typical, and the European party typically want to insist to put the jurisdiction in Europe, in their local home countries. And in the end, we often see these compromises that, okay, we put the contract under the Chinese jurisdiction, which we learned from this presentation. This is actually the better way to do so. But we add a arbitration location in another location, for example, in Hong Kong. So this is kind of the constellation we see often again and again. People sign contract with Chinese partner, jurisdiction is in China, mainland China, and arbitration location is in some Hong Kong arbitration center, something like that. So is this actually making any sense from your point of view, or this is totally unnecessary?
Well, I would say that for SMEs, arbitration is not advisable because arbitration is very, very expensive. While you know the standard judgments in China for the first instance can be issued in you know a limited time compared to, for instance, what happens in Europe. So probably in 9 months you can have a first decision. So it works quite well. Above all in those cities, in those let's say first tier cities like Beijing, Shanghai, Guangzhou, and Haikou, where there are IP specialized courts, but also in some new tier 1 cities like Hangzhou, Suzhou, Nanjing, courts are also very good. So and on the other side, let's say that there should be a consistency between the applicable law, the competent court, and so I would avoid to leave this, you know, the applicable law and in the Chinese law, and then the court in Hong Kong. But of course, then it's always a case-by-case assessment. So. And once again, you know if you did well or not after the you know the violation and the enforcement is happened. So our suggestion is to have a good support, good legal support in Europe and in China, and then try to use what the Chinese legal framework offers, because it's very good if you are able to use it.
Thank you.
Okay.
Okay, we have another question that popped up. So is YPO mediation or arbitration often considered as way to settle disputes in IP contracts in China?
Well, you can try to use a WIPO arbitration mediation, but once again, the arbitration can be more expensive always than a normal court decision.
Mm.
Yeah.
Right. I think we don't have any more questions. I don't know if Emon, do you want to add anything?
I'm good, I think. We will call the support hotline to get answers.
Great. Right, so thanks a lot, Elio, for your very useful presentation. We will share the slides with the audience, and you will receive an email with the link to the recording of this webinar. Thanks a lot, Emon, for organizing this very important training with me, and I wish everybody a good day and good luck for your business in China, of course, and do get in touch with us if you need any support on IP protection and enforcement. Thanks a lot, and until next time. Bye-bye, everyone.
Bye.
Thank you, Alessandra. Thank you, Elio. Bye-bye.
Bye-bye.